Criminal law. Mens rea. Recklessness in relation to property offences. Mens rea in criminal law refers to the state of mind of the defendant. There are different types such as intention, recklessness, dishonesty or knowledge. In general terms, being reckless refers to the taking of an unjustified risk. The meaning of recklessness in criminal law is set out in case law. Initially, one type of recklessness, Cunningham recklessness, applied to all offences. However, in 1982 the case of MPC v. Caldwell established an objective test of recklessness. This proved unpopular since it was capable of producing injustice. Later cases confined its application to property offences. This meant there were two different interpretations of recklessness applicable. One for offences against property, Caldwell recklessness, and one for offences against the person, Cunningham recklessness. Caldwell was overruled in 2003 in the case of RVG&R. However, the distinction between offences against the person and offences against property remained. The new hybrid test created in RVG&R applied to offences against property. In MPC v. Caldwell, the defendant had been dismissed from his job at a hotel. In consequence, he went out and got drunk. He then decided to set fire to the hotel in an act of revenge. He was charged with arson and being reckless as to whether life was endangered. He claimed that he was so drunk he had not given any thought as to whether his actions would endanger life. Had the court applied Cunningham recklessness, he would therefore not have been liable as he had not foreseen the risk. The House of Lords, concerned that the defendant should not escape liability due to his voluntary intoxication, introduced a new test for recklessness. Caldwell recklessness. A person is reckless as to whether property is destroyed or damaged where 1. He does an act which in fact creates an obvious risk that property will be destroyed or damaged. And 2. When he does the act, he either has not given any thought to the possibility of there being any such risk or has recognized that there was some risk involved and has nonetheless gone on to do it. Caldwell recklessness radically altered the law and received widespread criticism. It allowed liability to arise where the defendant did not foresee a risk. The tension between subjective and objective tests of recklessness continued. Each test was problematic. The difficulty with a subjective test is that it is based entirely on the defendant's state of mind. It is for the prosecution to prove that the defendant did foresee a risk of harm. It's difficult to prove a state of mind. It allows too many defendants to escape liability by simply claiming they did not foresee a risk. However, Caldwell recklessness is capable of causing injustice. It criminalizes those who genuinely did not foresee a risk of harm, including those who are incapable of such foresight. For example, in Elliott v. C., 1983, the magistrates accepted the 14-year-old girl with educational needs was not capable of foreseeing the risk of setting fire to the shed. Nevertheless, they were compelled to find her liable under Caldwell recklessness. Property offences were given greater level of protection as they were subject to Caldwell recklessness, whereas offences against the person including GBH, sexual assaults and rape were subject to Cunningham recklessness. The precise limits as to which offences required which type of recklessness were not fully understood or defined. Having two definitions for the same word was confusing. The test was difficult for juries to understand. Caldwell recklessness was eventually overruled by the House of Lords in RVG&R, 2003. The two defendants aged 11 and 12 decided to go camping without their parents' permission. They set up camp in the co-op car park. They found some bundles of newspapers near a wheelie bin and decided to light a campfire. When they decided they had had enough, they kicked the burning embers under the bin and went home. Unfortunately, the bin burnt. The fire spread to the co-op, causing over £1 million worth of damage. The boys did not foresee the risk of the co-op burning down. Had Caldwell recklessness been applied, they would have been liable. The House of Lords, however, overruled Caldwell and held a subjective standard now applies to criminal damage. The current test for recklessness in relation to criminal damage from the case of RVG&R. A person acts recklessly within the meaning of Section 1 of the Criminal Damage Act 1971 with respect to 1. A circumstance when he is aware of a risk that it exists or will exist. 2. A result when he is aware of a risk that it will occur. and it is, in the circumstances known to him, unreasonable to take the risk. In summary, a different test of recklessness applies to property offences and non-fatal offences against the person. For offences against property, initially Caldwell Recklessness applied. That proved problematic and was replaced with the current test set out in RVG&R. This is essentially a subjective test. To incur liability, the defendant must be aware of the risk. Additionally, it must be unreasonable in the circumstances for them to take that risk. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.